Last week, Congress passed a major piece of legislation called the Speak Out Act, which prohibits the enforcement of pre-existing non-disclosure and non-disparagement provisions, or NDAs for short, in sexual harassment and sexual assault cases. As of November 18th, the act has gone to President Biden's desk for signature, and he is expected to sign it into law.
The new law prohibits the enforcement of pre-existing NDAs in sexual harassment or assault cases. As a result, this applies to NDAs that are part of employment agreements, confidentiality agreements, and other similar contracts entered into well before any dispute or claim arises. It does not apply to NDAs signed as part of settlements of such cases. It also doesn't apply to disputes involving other forms of harassment, such as harassment on the basis of age or race, or disputes involving other employment-related complaints, such as wage complaints. And the law will not prohibit an employer from protecting its trade secrets or proprietary information.
The Speak Out Act is the latest piece of legislation inspired by the Me Too movement. Earlier this year, Congress passed a law prohibiting the mandatory arbitration of sexual assault and sexual harassment claims. Employers across the country should prepare for the new law by checking their NDAs to see what, if any, carve-outs are already in place applying to these provisions. Often, there is already language about the NDA only applying to the extent allowed by law. However, this language alone may not be enough. Until there is litigation involving this new law, employers might not be comfortable with such risk. As employers will want to maintain the broadest protections possible, their standard NDA provisions could for the most part be maintained, with language carving out application in cases with allegations of sexual harassment or assault.
Further complicating the landscape, Washington, Oregon, New Jersey, and California have already passed bans on NDAs for all types of workplace issues, and New York legislators have introduced a bill currently drafted as even broader than the Speak Out Act.
New York employers should note that New York law already prohibits including the non-disclosure provisions in settlement agreements resolving discrimination claims, except where it is the complainant's preference.
For more information, please reach out to a member of our labor and employment team.